Welcome to the fourth edition of Legal Affairs. I'm Stephen Yap. In the studio this afternoon, we have Professor Albert Chen, who is a senior consultant of the Hong Kong Legal Exchange Foundation, and also the National People's Congress Hong Kong Basic Law Committee member. Good afternoon, Albert. Today we will talk about traditional indigenous rights and small house policy. Now, people know that male indigenous villagers have a right to build a small house upon new territory's land. Now, this right has been around for hundreds of years, and the basic law protects and extends this right beyond 1997. Now, someone challenges this right in our court. Now, Professor Chen, please could you give us a brief introduction to the traditional indigenous rights and the small house policy?
Yes, this is a very important issue covered by the Basic Law. Article 40 of the Basic Law protects the so-called lawful traditional rights and interests of the indigenous inhabitants of the new territories. So that provision was drafted and enacted into law in 1990. It was quite controversial at the time and has remained controversial since then, but no legal challenge has been brought before the court until a few years ago. Now, this so-called small house policy, in its present form, was adopted by the government in 1972. The colonial government and its executive council adopted this policy. So there are three prongs of this small house policy. Number one is free building license, number two is private treaty grant, and number three is land exchange.
Now, it is said that the small house policy is discriminatory against two groups of people. Now, first of all, the policy was designed to offer male indigenous villagers exclusively a right to apply for a small house. Now, this totally discriminates against the female indigenous villagers, as they are not allowed to apply for a small house grant. Now, what is your take on that?
Well, the policy is indeed discriminatory in a technical sense, and it was also recognized by the court. It is discriminatory in the sense that women are not entitled to get the small house grant or license. And secondly, it seems to be discriminatory against people who are not indigenous villagers. So even if they live in new territory villages, if they are not indigenous villagers in a sense defined by law, then they are not entitled to the small house policy. So even the court recognized this and held that there was actually no good justification for the discrimination. So the policy would have been declared unlawful or unconstitutional, but for the provision in Article 40 of the Basic Law seems to sanction this policy, irrespective of whether it is discriminatory against certain people or not.
So, whilst it is said it's discriminatory, would there be any way that one would try and dispel this argument?
Well, it seems that Article 40 of the Basic Law is the only legal basis relied on by those who support the continuation of the small house policy. Actually, this matter was litigated in a case called Kwok Chuk Kin and Director of Lands, which was heard by the Court of First Instance and then subsequently by the Court of Appeal. The Court of Appeal disagreed to some extent with the Court of First Instance. Actually, two courts adopted different approaches to the interpretation of Article 40 of the Basic Law. So in particular, they have different interpretations of how to determine what is the lawful traditional right and interests of indigenous inhabitants of the new territories under Article 40. So according to the Court of First Instance, we have to do what is called a tracing exercise. We have to find out whether a right or interest is traditional. We have to go back to 1898 to see whether the rights already existed in or before 1898. And if the right already existed at that time, then the right would be protected under Article 40 of the Basic Law. But the Court of Appeal believed that the tracing exercise is not necessary. The Court of Appeal looked at the context of the enactment of Article 40 of the Basic Law and how that the Article 40 was actually intended to protect rights and interests of indigenous inhabitants of the new territories, which were recognized at the time of enactment of the Basic Law, which was the year 1990, recognized by the legal system at that time as lawful and traditional. So the court, on this basis, the Court of Appeal held that at the time the Basic Law was drafted and enacted, the lawful traditional rights and interests of new territories inhabitants were indigenous, included already the rights protected or covered by the small house policy. So the Court of Appeal upheld the whole of the small house policy.
Okay, thank you, Professor Chen. That is the program for today. Thank you for watching Legal Affairs. See you next time.